Good afternoon. Happy Halloween. Blind Justice a day ago accused the judge in my comment section of criminal action, and I gave him some time to come back and answer, and now he's answered. And so now that I know what he's accusing the judge of, we'll go through the comment and figure out how, where, and why how Mikey got it wrong, I should say, I guess. I don't know. First of all, I had asked him for any documents so that I could review the documents so I could better understand what's going on in the case. And he says there aren't any documents for the trial as it's not a court of record. And there are always going to be documents. There's going to be some sort of a judgment form, or maybe the judge can do it on pleading paper, but there's going to be something. These are both from the state of North Carolina. There are optional forms, and there may be other criminal judgment forms available for the use in district courts. Maybe local forms, maybe there's computer-generated forms. I'm not entirely sure of what's going on. I don't practice in North Carolina. I'm not licensed to practice in North Carolina. So I'm not entirely sure of what's going on, but I do know if there is a judgment, it is going to be a written judgment. That is just the way it works. No state is going to impose a criminal penalty on you without some sort of a written judgment. So that's kind of what I'm looking for. Hopefully be on pleading paper, because a lot of times the judge will go through the facts of it and he'll lay out, this fact, and this fact. This is what I found. I found X, Y, and Z based on this, maybe this case, maybe this statute, whatever. Based on all of this, this is how I came to this conclusion. Hopefully it would be something like that. But even if it's just a form like this, offenses, see this big spot in here, that's where the judge can make his findings and things like that, etc. There's big spots for the judge to put stuff in. So that's what I was looking for. He says, as for the consensual encounter, the prosecution was specifically talking about me and not the driver. He agreed that I could have walked away from the stop in spite of common sense. We all know that if I tried to walk away, they would have detained me immediately or worse. Well, that's an interesting proposition. When a vehicle is pulled over, the occupants are seized. They're all seized. However, an occupant other than the driver has specifically been detained. But the other occupants may, in fact, be free to go. And, that would be interesting. What would have happened had you asked if you were free to leave? That's interesting. That doesn't make a whole lot of sense, because the officer was talking about trespass, and I believe is still talking about trespass, although I may be wrong. Again, I don't have the documents. But if it was trespass, then both you and your wife would have been trespassing, or at least the officer would have suspected it. Again, I don't believe that there was a crime of trespassing being committed there. I don't believe that anything that Mikey did rose to the level of trespass, criminal trespass. I don't believe that to be the case. For everybody who talks about Mikey criminally trespassing that night, they are in error. It is not supported by the facts or the law. That's why Mikey wasn't charged with criminal trespass. There is nothing about criminal trespass available for that stop. The officer might have had reasonable suspicion for a variety of other crimes, but trespass should not have been among them. So there you go. He says, after filing the appeal for trial de novo, Judge Freeman threatened my attorney with contempt for pointing out the judge's crime. Now, this is what the crime that I'm concerned with. An attorney should not be threatening a judge with crimes. That's not what you do as an attorney. If you believe that the judge has violated some sort of judicial ethics or what have you, you would report him to the bar. Maybe there is some sort of a judicial ethics committee that you could report him to. But that's step one. Step two would be to report him to a prosecutor. But you don't walk into the judge's court and say, Your Honor, you're a criminal. Because you're in the judge's court. Yes, that is absolutely appropriate for a judge to threaten an attorney with contempt for calling the judge a criminal. You got to show respect to the office. Once you're outside of the judge's court, go to the state bar or whoever the reviewing licensing agency would be. File a complaint. Talk to a prosecutor. But there's ways to do it that aren't stupid. And if in fact your attorney did, quote, point out the judge's crime to the judge in court, then your attorney is not good. So I'm hoping that you are misunderstanding what your attorney did and what was going on there. I'm hoping that. But I did ask, accusing the judge of a crime. Lol, pray tell what crime? And he responds back, NCGS, that's North Carolina General Statutes, 14-230, willfully failing to discharge duties. That's step one. We're going to go there first. He also accuses him of 18 U.S.C. 241 and 242. But we're going to start with 14-230. Willfully failing to discharge duties. A, if any clerk of any court of record, sheriff, magistrate, school board member, county commissioner, county surveyor, coroner, treasurer, or official of any of the state institutions or of any county, city, or town shall willfully omit, neglect, or refuse to discharge any of the duties of his office for default whereof it is not elsewhere provided, that he shall be indicted. He shall be guilty of a class 1 misdemeanor if it shall be proved that such officer after his qualification willfully and corruptly omitted, neglected, or refused to discharge any of the duties of his office, or willfully and corruptly violated his oath of office according to the true intent and meaning thereof. Such officer shall be guilty of misbehavior in office and shall be punished by removal from or therefrom under the sentence of the court as part of the punishment for the offense. Subsection B, no magistrate recusing in accordance with GS 51-5.5 may be charged under this section for recusal to perform marriages in accordance with Chapter 51 of the General Statutes. Now, why doesn't this work for Mikey? It's a very simple answer. The very simple answer is it applies to magistrates, but it doesn't apply to district court judges, superior court judges, appellate court judges, or Supreme Court judges. It only and solely applies to magistrates in the judicial scheme of things. Magistrates are appointed by, I believe in North Carolina, they're appointed by the Superior Court judge to serve in the district court for like petty offenses, like traffic tickets. And not misdemeanors, but like traffic tickets, I think indictments, like filling out, like signing arrest warrants, basic stuff like that. The judge that Mikey has a conflict with is Freeman. He is a district court judge. So this does not apply to a district court judge. So if your attorney is accusing a district court judge of failing to comply with or being in violation of General Statute 14-230, your attorney is trash. However, I doubt your attorney believes that the judge is in violation of 14-230 because I can't imagine someone being that incompetent. It took about 2 seconds for me to figure it out. And it took about another 5 minutes of Googling for me to look up a few cases in North Carolina to verify what I believed. But yes, it does not apply to judges. It only applies to magistrates in the judicial realm of things. And then he says willfully fail. And then he says 18 U.S.C. 241 and 242. Well, okay. 18 U.S.C. 241 is conspiracy against rights. Now, in order for the judge to be in violation of 18 U.S.C. 241, he has to conspire. It has to be 2 or more persons conspiring to injure, oppress, threaten, or intimidate. And those words have meaning. Saying I'm going to be your judge, and it's a bench trial, and I am going to determine the facts and the law, and then sentence you accordingly. If I find you guilty, sentence you accordingly. That is not a threat. That is a statement of what is going to happen. That's the process. So intimidate any person in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States or because of his having so exercised the same. shall be fined or imprisoned, blah, blah, blah. So the big failure here, number one, well, the big failure here, let's just leave it there, is that you'd have to prove a conspiracy. You'd have to prove two people. So far, you've just got the judge saying that he conspired with the prosecutor. I mean, good luck. Good luck. It was done in open court, so good luck. The next one is 242. Now, I spent a little bit of time looking at this one, and I looked for any cases where there was a judge who was actually charged with and convicted of 18 U.S.C. 242 for arriving at a conclusion of fact and law and applying it the same. There are Supreme Court cases talking about judicial discretion in sentencing, where it doesn't violate the Sixth Amendment, etc. There are 18 USC 2. There is an 18 USC 242 case where a judge in family court brought several ladies back into his chambers and essentially raped them. But he used his authority as a judge to get those ladies there and to try to hush them up. And if they said anything, then he would rule against them in their family court proceedings. But there is no precedent for 18 U.S.C. 242 to be used because the judge didn't reach the finding of fact and or law that you prefer. So that's number one. And number two is I have not seen where you've been denied any of your rights. You have been given notice and hearing. You have had the opportunity to cross-examine your witness. You've had the opportunity to be represented by counsel. You've had the right to remain silent. I don't believe that you have been forced to take the stand or speak. What right have you been deprived of? And the cherry on top of this is that you have the automatic right to an appeal to a trial de novo, which means that everything in that lower court, in that district court, is moot. The judgment is moot. Any decisions that the judge made about discovery, gone. The only thing that's left is your bond hearing, your bond conditions. But in North Carolina, you've got 10 days to file that appeal, and the district court judge has jurisdiction over you for the bond for those 10 days. So there you go. Judge and DA wanted me present for a appeal bond hearing hours after the appeal is filed. Well, there's generally going to be an appeal bond hearing. And if the appeal bond hearing, if you wait till the last day, then there's not a lot of time. Lawyer argued that demanding my presence the same day is another violation of due process. Well, that's fine. He can argue that, but that doesn't arise to criminal action. Judge Freeman set the bond for the same $50,000 in house arrest and cited the fact that I've made YouTube videos about him. Well, so your bond was $50,000. As far as a house arrest is concerned, I'm not entirely sure where that came from, but without anything to determine it, that is within his power as a judge to set that. And the fact that you've made YouTube videos about him, yeah, you're making those YouTube videos presumably in an attempt to coerce him or to threaten him to try to alter to alter his judgment. So yeah, I can see why he would do that. Keep you inside because you are a problem. The judge punished me for appealing his decision. No, he didn't. Because the judge had made a decision about your bond, that your bond would expire or your bond would be returned to you when the 10 days were up. So normally what happens is you show up at court and your bond gets returned to you. You showed up. The judge at that hearing made a decision at that trial, made a decision that your bond would be refunded to you, I believe, after you completed your 10 days of community service, which extended the time frame that your bond was not returned to you. Now, once you appealed, that extension of time is gone, right? And Your bond, because you appeared, should then be returned to you. So they need to get you in right then and there to reinstitute the bond, because now you have another upcoming trial and they need to secure your appearance at it. He's not punishing you for appealing his decision. He is reinstating the bond, the same bond that got you to show up the second time, I guess. Because the first time you were standing outside pouting because you couldn't bring your toys in. And for exposing his crimes on the internet. You have not exposed a single crime on the internet. So now I'm on house arrest again. Well, that's probably good for you. It'll keep you out of trouble because I think you've had several misdemeanors this year. So maybe a little bit of a house arrest is good. Spend some time with your kids. Maybe spend some time doing some online research, figure out where you're going wrong, because you might notice that your understanding of the law isn't working out for you. If every time you go in to court, you lose, if every time you get in an argument about ADA provisions, you lose, maybe you're misunderstanding things. Maybe you should get an attorney who doesn't show up and in court point out the judge's crime. Like that's going to help you get a lower bond. I hope to God your attorney didn't do that because that's dumb. He says that's a major violation of the 5th and 14th Amendments and due process. Okay, so your 5th Amendment due process is secured to you through the 14th Amendment. So I don't know exactly why you're splitting all those up, but you're getting due process. You had notice. He gave you hours of notice, right? Not a long time, but he gave you hours of notice, but he did give you notice. And you had an attorney present. You had a hearing on it. You had due process. I appreciate you keeping me apprised as this develops. And for now, with no one inside, I'm a prisoner in my house. Good for you. Anyway, I hope that makes sense to everybody. Mikey's being overly dramatic. The judge did not do anything wrong as far as I can see. I mean, you may disagree with his decision, and that's fine. That doesn't arise to a crime. Thanks for watching. Have a great day.